Hello, I am Adeola Adejobi, along with my co-host, Jason Clark, and I want to welcome you to Raising the Bar with the MBBA.
The Metropolitan Black Bar Association is the largest association of predominantly African-American attorneys in New York. Our mission is to advance equality in the pursuit of justice, assist the professional development of our members, and 3, address legal issues affecting New Yorkers. The goal of Raising the Bar with MBBA is to foster a substantive conversation about justice issues in our community while also identifying solutions in the process.
Today, we are going to take a deeper dive into employment discrimination. Joining me now is the president of the Association of Black Women Attorneys, Tonya, and employment attorney, Natayla Johnson. Welcome.
Thank you.
So we have a lot of material to cover today, so we are going to jump right in. Complaints arising out of alleged employment or workplace discrimination has increased significantly over the last few years. Can you provide our viewers with a brief overview of some of the most common workplace anti-discrimination laws?
Sure, and thank you for that question, Adeola. So we'll start here. One, the anti-discrimination laws include federal and state and local laws. I'm not going to delve too much into the actual law itself. I think it's best that we focus on what these laws protect. But just to give you a primer, Title VII of the Civil Rights Act of 1964 protects against race discrimination, gender discrimination, national origin discrimination, discrimination based upon your color. You also have comparable state laws and even local laws that protect other what we call suspect classifications.
Okay.
And those suspect classifications will include disability discrimination. Under the New York City human rights law, more recently, there is a law that was implemented to protect against or ban against discrimination based upon hair. And as we all know, the uptick has been considerable with respect to gender discrimination, specifically as it relates to equal pay, as well as sexual harassment.
Okay. And I would say, for clarity, can you just go back to what are some of the characteristics that are protected under anti-discrimination laws?
Sure, so I'll repeat. So it's race discrimination, gender discrimination, sexual orientation, discrimination based upon age, disability. There's even a law that protects against victims of domestic violence. That's more of a broader law under the New York City human rights law, marital status. So there are a breadth of suspect classifications, and Natayla will talk about something about where those protections apply depending upon your region.
Okay. Yeah, Adeola, you bring up a really great point, and Tonya, thank you so much for emphasizing that. There are actually additional protected categories depending on where you live.
Oh, wow.
Because each state has its own anti-discrimination statute. So for example, in New Jersey, protected characteristics also include military status, genetic information, and even something like breastfeeding.
Oh, wow.
Okay, and then when we're talking about New York, for example, one of the things that was interesting to me is I feel like the New York City Human Rights Commission, in addition to the ones that you just said, it seems like there's like a plethora of different classes or people that are protected. So let's say that you're an employee and you feel like you had been discriminated in some type of way. Like, what should you do? Like, what are the different steps you should take?
So if any employee specifically feels that they were the victim of any type of discrimination, including the suspect classifications that we've identified here, the suggestion is to go internally. Tell your direct supervisor, tell the designated person who is designated to receive complaints, and that person is typically the Equal Employment Opportunity Officer. That's where I would start in complaints for purposes of discrimination. When it comes to equal pay, which is what Natayla will talk about, she'll touch upon where you need to go or where you should go for purposes of complaints about employment discrimination as it relates to equal pay.
And just to follow up on one of Tonya's points, recent legislation, for example, with regard to sexual harassment requirements, actually mandate that employers with specificity outline internal complaint procedures. So in addition to the external administrative agencies where you can file complaints outside of your employer's ambit, there also should be a mechanism for you to file your complaints internally and hash out whatever grievances you have there.
Okay, But in New York City, there are a lot of small businesses, startups, et cetera. Now, what if someone is experiencing discrimination there and there is no EEO officer internally? What should they do?
Now, if there is no internal EEO officer, which we encourage that there should be, or an ombudsman internally in the organization, there are agencies outside, external agencies, one being the Equal Employment Opportunity Commission, which is where you would file any complaints for any of the suspect classifications that we've described. There's also the New York State Division of Human Rights. So under anti-discrimination laws, as Natayla highlighted, you have federal, you have state, and then you have local laws, which would be here New York City local law. You can file a complaint at the New York State Division of Human Rights, and then also there is also a New York City Commission on Human Rights, where you can also lodge complaints of alleged discrimination.
Yeah, so there are actually a lot of
that's like 3
options
places,
and a lot of alternatives. And the good thing is that they have a work sharing agreement. So you can actually file your complaint with one of the administrative agencies, and it's like a cross filing across some of the other
really?
agencies. Yes.
Okay, that's good information.
And this, I'm assuming, includes if you're a freelancer, right? Or if you've only been working at a position for X amount of time. I mean, I think maybe this is some of what you were going into, Tonya, but today it's really there's so much more of a work share environment. And a lot of people like that, but the drawback some people look at sometimes is some of the protections that you usually have when you have a union, for example, aren't there because you're there as a freelancer or you're coming in. So it sounds like there are protections that are available for you in those circumstances.
Yes, and that's a good point you bring up, Jason, because there is a New York City freelancer law, right, where freelancers now are protected by the anti-discrimination laws in New York City and New York State, and they can also file complaints with the New York City Division of Human Rights or Commission on Human Rights of any alleged anti-discrimination or any alleged discrimination that they experience while at their employer.
Okay, and so the freelancers also include independent contractors, I guess,
Right,
for sake
so
of terms.
freelancer is an independent contractor, correct. They wouldn't be employees per se.
Yeah.
Okay. So another topic has to do with gender equity and equal pay. So Natayla, what are some of the updates that you can provide us on when it comes to those issues? And then as well, maybe we can also start to transition also talking about as it relates to disability laws.
Okay, great question. So actually over the past 3 years, multiple states and localities have started to enact laws prohibiting employers from inquiring into a new job applicant's salary history. And so essentially the premise of these laws is that there should be equal pay for substantially similar work. Or if you're setting pay scales for an applicant, really the pay should be commensurate with their experience and with their certifications and their speciality. And the thought is this: if a person is continually forced or compelled to disclose their salary history and they already have a lower salary based upon past pay discriminatory practices, you're just perpetuating the gender wage gap. And you're also perpetuating the disparity between wages that exists, unfortunately, amongst different racial groups as well.
And I think that's actually an amazing point, particularly because women generally, at least the stats show, that women get paid less. And so going from job to job, if you have to disclose your salary, you now then will continue to get paid less, even though you have more experience.
Yeah, no, great point. And so it's interesting. People think, oh wow, laws banning an employer's ability to inquire into salary history. How is that mitigating the gender wage gap? But to your point, that's exactly what's happening. And what New York has done is it passed its own version of the law, New York City, and it's called Local Law 67. And it actually went into effect October of 2017. And it applies broadly. It applies basically to all employers, regardless of your size. And its ambit and scope is pretty large. So the law is written so that it applies and it's effective if the impact of the discriminatory pay practice is felt in New York City. So for example, you can ultimately seek a job in Florida, but the company is headquartered in New York City and the interview takes place in New York City and the law still applies.
Wow, that's very broad.
What's interesting about what Natayla mentioned, and that the viewers should also know, is that while the employer can inquire into salaries, the employee or the prospective employee, if they share that information, i.e. their prior salary, that can be used by employers in in calculating as one factor in calculating the salary. So employers cannot use that or inquire, but prospective employees should be aware that maybe you want to consider whether you're going to share your prior salary or not during your interview.
That is an awesome distinction because it even goes further as you delineate between the public sector and the private sector. So as Tonya said, voluntary disclosure, of course, cannot be forbidden. You can voluntarily disclose what your pay history is. And then in the private sector, the employer can then use that information to then set the salary history. However, under an executive order pertaining to government jobs, even with a voluntary disclosure, you cannot use that information to then set the salary. So a lot of distinctions there.
So that's interesting. So let's say I'm on a job interview, and it seems like it's going well.
Where?
Okay, let's say, all right, well, let's do both. Okay, so first I am applying for a government position here in the lovely state and city of New York, and things are going, swimmingly. And all of a sudden, even though I know this information because I'm watching Raising the Bar with the MBVA and I know what my employment rights are, what if an employer does ask me that question?
Well, in the public sector, you mentioned,
first
correct?
in the public sector, right.
The public salaries are typically made available, right? They're readily available. Anyone can access public salaries. They may not be as up to date and accurate, right? The availability may have been 2 years or a year ago, but they are readily available. So anyway, so that's known. So I'll let Natayla circle in on what happens once that information is used, but that information is already made available, whereas in the private sector, it's not.
Yeah, excellent point, Tonya. With regard, one of the actual distinctions with this law is that it's not applicable to internal transfers. So it's really a law that's focused on new applicants, completely new, no history with the employer whatsoever. So if you're moving from one division to another, most likely that information is already available and you're already considered an internal applicant. So the inquiries can be made.
So laterals? Sorry.
Yeah.
Right. But to that point, so let's say we're in we're talking about a private company now, and the same situation happens. What would you tell somebody then?
So a lot of the onus is on the potential employee and the applicant, and knowing that this law exists. So again, it's far-reaching. So it applies to any agent of the employer, right? So it can be their headhunter, it could be a staffing agency, okay? It could be a recruiter. The same prohibition on the inquiries apply. So as the employee, even if the pressure is being put on you unjustly so, you should just use different tactics to steer the conversation in the right way, because it's uncomfortable. You want this job, right? So what employers are allowed to inquire into are expectations as to salary. So if someone asks you straight up, well, what did you make? Well, I'd rather have a conversation about what the pay scale is for a job category that's commensurate with my skill set and my experience. Or I'd rather have a conversation based upon this expected salary, and you steer the conversation that way. So that's how you can deal with it on the front end. On the back end, if you feel like an employer has really violated this policy, there's a private right to action with the New York City Commission on Human Rights, which means you can sue them, you can seek recourse, and there are penalties because the law has actually been absorbed into the New York human rights law.
So, I mean, in New York, very broad, a lot of protections for individuals. Can you talk more about maybe what other jurisdictions may or may not be doing in terms of having a policy or laws that are similar to this?
No, great question, because this definitely is a trend that's taking off nationally. So multiple states and localities have enacted their own versions of this law. For example, it's evident in the private sector in New York City. Suffolk County is going to go into effect in 2019, Albany, Westchester. So it's definitely something that's taken place across different states in the nation. So I tell employers that I counsel, it's just better to have a uniform hiring policy to inform consistency. But there also have been jurisdictions in cities and states that have rejected the trend or tried to reject the trend. Oh, wow. So by way of one example, Philadelphia. Their law was supposed to go into effect in 2017. Right before the effective date, the local Chamber of Commerce went to court and they basically commenced litigation to hold the law unconstitutional because they wanted to say that it was an infringement on their First Amendment rights. First Amendment rights of employers. You cannot infringe on their ability to ask something. So that was very interesting litigation. And then other states, like in 2018, I think Michigan and Wisconsin enacted bans on the bans. So these states essentially said, localities, municipalities, you cannot enact laws that prohibit an employer from inquiring into a salary of an applicant. So, but those are definitely the minority jurisdictions.
Wow, so it sounds like New York is pretty progressive when it comes to employment law protections, which is good to hear.
Absolutely.
Particularly New York City.
New York
It's
City.
much more progressive, yes.
Right. Oh. And then I guess to that second point, when we're talking about disabilities, right? Let's say, I'm someone who has a disability and, at least from the stories that I've heard, and I would imagine a lot of these, the discrimination may be a little bit more nuanced. It's not somebody coming out there saying, I'm not going to hire you, or I don't like you because you're blind, or I don't like you because you're in a wheelchair, or what have you. What should somebody know if they have a disability and they feel like they are being discriminated against in some type of way?
That's a great question, Jason. And what I'm going to do is the disability laws that I'm going to focus on for that question is this New York City Commission of Human Rights Disability, right? So disability discrimination, as you're articulating, we mentioned earlier, is prohibited. Anti-discrimination laws is a federal law on that as well. So on October 16, 2018, the New York City Commission on Human Rights, or the council, passed the law. And that law basically said, if you are an individual that has a disability, if you are an individual that is pregnant or suffering from pregnancy complications, if you are an individual that has a religious or needs a religious accommodations, or one that have been the victim of some type of sexual harassment or domestic violence, your employer must engage in what the statute calls a cooperative dialogue. And what that just means is a conversation, right, with your employee to discuss potential accommodations. Accommodations are advantages or opportunities or extending to your employee a benefit that will assist you in your employment as a result of your disability. Now, Natayla had mentioned a private right of action. To the extent your employer does not sit down and have this conversation with you, then that entitles you to sue your employer as a result of solely not having that conversation. Now, that's distinct from a complaint or plenary action as it relates to the underlying discrimination, i.e. you discriminated against me because I was disability, or you didn't employ me because, or rehire me because I was pregnant, or I shouldn't say rehire, you didn't, when I came back from pregnancy leave, you terminated my employment, right? So that is interesting, and that is something that's very popular in New York City right now, and it's a mandate on employers. So employers need to consider that, because disability discrimination is very thorny. One thing that the cooperative dialogue also requires is not only an engagement, but suggestions from the employee as to what accommodations would assist the employee in their employment practice, as well as suggestions from the employer. So any accommodations that may impact the employer's business has to be taken into consideration. A best practice would be to record this information, to record this conversation, so that individuals, should a plaintiff come and say, or employee come and say, oh, you didn't engage in this dialogue, we have documentation to say that we did. It's not required. Has to be oral or in writing, but that's some of the best practices that employers should take, particularly with this particular statute.
Okay, I want to hone in on the pregnancy aspect, because that really does affect women. And so what you're saying is that if a woman's pregnant, she can ask for accommodations from her employer.
Absolutely.
And they have to provide those.
Absolutely.
Okay,
and there are
that's good to know.
various accommodations, right? So the way that the law looks at it is, for example, pregnancy is not a disability, right, under the law, as we know. So, but should you give, let's say, someone that had a broken leg or a knee time off, let's say you gave them 6 weeks time off, right, to recover from that particular injury, then you cannot deny then a woman that's pregnant, who, let's say, is having some pregnancy complications, the same time off, right? You must treat them similarly situated, right? Similarly. As it relates to pregnancy discrimination and pregnancy accommodations, breastfeeding. right? That's an accommodation that you need to provide your employees to the extent that they need areas by which they can breastfeed. Doctor's appointments, right? You need to provide your employees with the proper time, allocation of time in order to go see their doctor. Those type of accommodations, not necessarily those that require you to be out of the office for long periods of time, but just to modify some of the times in which they are in office and be a little bit more lenient.
From the employer and the employee standpoint, as they engage in this interactive process regarding accommodations, it's equitable preferences and equitable opportunities. So if one thing is extended to one person because of their perceived or actual disability, you have to be cognizant that the same type of opportunities also have to be allotted and provided to other people. Otherwise, it gets very thorny, as Tonya said, or you get into trouble for not being equitable in terms of your accommodations.
Right.
And it doesn't benefit employers not to, accommodate. Like, employers are not in the business of discrimination, right? That doesn't benefit them economically, and it doesn't benefit the environment for which their employees work, right?
Right.
They're not, as a general matter, but agree, they shouldn't be. So yeah, some of these laws are just to monitor, to some extent, where there are instances in which there appears to be some type of discrimination in the workplace.
So to that point, even though we're even joking at that point, I mean, I imagine most people, like you're saying, aren't out there to discriminate against folks. But I would imagine some of the pushback from some folks would be is, let's say I'm not a Fortune 100 business. Let's say I'm a small business and we're just getting started. And somebody is coming in who I may want to hire, but maybe because we're at a startup phase or because we are, aren't making a lot of money, we may not be able to provide all of those accommodations. So what is the pushback there, or what should someone who's a small business owner who may have some of those concerns also think about from the other standpoint?
As a general matter, seek counsel,
Yeah.
right? That's the first thing I'm going to.
Right.
Yeah, seek counsel. Those obstacles and sometimes struggles are definitely ones that startups and sometimes not-for-profits experience, right?
Yeah,
To be quite honest with you. And there are big, strong concerns. However, notwithstanding those concerns, we still must comply with the law, right? Anti-discrimination law. So it's a balancing act. Again, seek counsel.
And the key word that Tonya just said is balancing act. So everything is not necessarily in favor of the employer or the employee. If a claim is brought, the law is also considering the burden, right, that's impinged upon the employer in terms of a requested accommodation as well. So they're always looking at things from a factual standpoint.
But to your point, Jason, if one employee, right, was out for 6 months for whatever reason, right? It's hard for the employer to now come and say this is an undue burden to give another employee who needs an accommodation a 6-month period off, right? That's hard to defend and suggest an undue burden. So you need to be consistent. Right, have policies. I think as a general matter, best practice for employers are to be consistent, and also for purposes of employees to share this information with their employer. Now, under the New York City human rights law, as it relates to the cooperative dialogue, there is the onus is on the employer, right? So it's not only they deem the employee to need a reasonable accommodation, i.e. the employee came and shared, I need a reasonable accommodation.
Right.
They didn't have to say those words, right? But I need time off, right, for this particular issue, health issue. But also the onus is on the employer to have constructive notice. If you see your employee coming to work late every day or calling out, and you can't inquire as to why, but they volunteer information as to why they're calling out medical issues or concerns, then now this is a time in which you need to maybe start to have a conversation and offer some accommodations to that employee, or at least begin the dialogue.
Okay, and then actually, just so I'm clear, so when we're talking about accommodations, are the accommodations that are quote unquote reasonable, is it dependent on the size of the business, or is it the same regardless of the business that you have?
Reasonability is a defined term under the law. So it's hard to it's fact specific, right? Like that's when it starts to, that's when you start to get a little bit more complicated into how the law is looked at. What's your burden? Who has the burden? When does it shift? But reasonable is a defined term, but you know that as a general matter, if you gave it to one,
Right.
That's a
Right.
good rule of thumb.
Yeah.
Then
should be able to give it to the other.
you have to consider giving it to the other. Or at least under this law, have a dialogue.
Okay.
And I want to touch upon something that Tonya said that's super important, and it's about what triggers, right, this dialogue from the employer standpoint. And because I've seen plenty of complaints where the allegation is such where it says, she knew, the employer knew, or should have known, right? And so that goes back to what Tonya was saying in terms of you have to be aware of what's going on with your employees because anything might trigger the actual dialogue to take place.
Right, and I know, Natayla, you talked about employers need to have some sort of protocol internally when it comes to this, and I just want to take it back to the small businesses and startups. Is there a certain number of employees that triggers this, or if it's 2 people, 3 people, 5 people? Because generally, small businesses they're trying to make money and grow. They're not really thinking about these internal policies. So is there a particular size or amount of money that a business makes that kind of triggers them having to have this internal policy?
So it depends.
Okay.
It depends on what law you're talking about.
That's right.
The salary history ban laws, it applies to all employers, no matter what. The New York City Commission on Human Rights usually is for employees or more. But with sexual harassment laws and those requirements in the recent legislation, it also applies to everyone.
Right.
So it really is, you have to be diligent about, as an employer and an employee, in terms of what laws apply and just making sure you're covering everything.
Okay.
I want to thank our guests for being here with us today.
And thank you for watching Raising the Bar with the MBBA. To watch our other shows, you can visit mnn.org. Until next time, bye.